are a child. So the project that I'm involved in, what we try and do is we work with NGOs who have asylum seekers and migrants, non-asylum seeking people, as their service users.
Would you mind if I record this? Because there's really good stuff on my phone, like voice record you.
Sure.
Okay.
All right.
Sorry, 2 secs. Great.
And what we do is where people, the organisations are coming across problems that are recurrent. So it's the same issue affecting a lot of their service users, and they're trying to negotiate with the Home Office to kind of resolve that problem, because the Home Office does have meetings on a periodic basis where it meets with NGOs and representatives of NGOs kind of to talk about issues. And obviously there's correspondence, whether it's directly with the Home Office or through MPs and other politicians and so on, to try and then kind of see if we can come to an agreement that what's happening is wrong and what can be done about it. And frequently, because immigration and asylum is such a politically sensitive issue, it's quite difficult to resolve things in a consensus manner, and often some of these issues have been persisting for a long period of time, where the NGOs have tried to negotiate and just got nowhere. In those circumstances, depending on what the issue is, we will work with the NGOs to see if there maybe the only way to resolve it is to ask the court to decide whether what's happening is right or wrong, and if we think that it is appropriate for the court to decide, then we will act for either the service users or the organisations themselves in legal proceedings in the court. So that, broadly speaking, is what we do, is to try and challenge underlying systemic problems impacting on more than a few asylum seekers, because with the cuts in legal aid and the reduction in the number of good, competent lawyers doing this area of work, because it just doesn't pay enough for people to run it as a business, then you might have an issue that impacts on hundreds or maybe thousands of people. So one lawyer may be able to resolve the issue for 10, 20, 100 people. If there's 1,000 others who can't get to them because of restrictions on legal aid or capacity, then that underlying problem still continues for those people. So the idea is to see how we might be able to resolve that for other people who can't gain access to lawyers as well.
No, we read up about your the organisation and what you do and how you work with, not just asylum seekers, all different forms of migrants coming into the country, but with what you said with the whole the persisting issues that happen, like that where you bring the courts involved, could you give us maybe an example or a really popular one?
A very recent example, which is still ongoing, is the fact that for a long time the UK government has had a policy of detaining asylum seekers, not because they've done anything wrong or it's thought that they might run away if they're not detained, but simply for the Home Office's own convenience, on the basis that the way the policy was introduced all the way back in 2000 was that there were quite a high number of applications for asylum to the UK from nationals of principally former countries which were part of the Soviet Union, and which were going to become part of the EU, countries like Poland, what is now the Czech Republic, Slovakia, Lithuania, and so on. And so the UK felt that they were asylum applications from countries where there wasn't really a fear of persecution. And so, but there were so many people making an application for asylum, they needed to detain people for a short period of time, they said 7 to 10 days, in order to just make a decision on their case. And about 80% of those people, when their application was refused, were released from detention. And they felt the pressure because they had to conduct so many interviews that it just wouldn't work unless the people were detained. And then in 2003, the government kind of extended that policy by also detaining people, even where they'd been refused asylum and they were exercising a right of appeal, whilst their appeal was being decided on the basis that a lot of these people were coming from countries where the UK government felt there was in general no risk of persecution. And that process, including the appeals, has been going on now for nearly 12 years, because it was introduced in around March 2003. And then over the past at least 6 years, probably longer, there have been persistent concerns expressed by a number of NGOs, non-governmental organisations, like Amnesty International, Bail for Immigration Detainees, Freedom from Torture, the Helen Bamber Foundation, and others, including the UN High Commissioner for Refugees, about how that process is working. And there was a real concern that there were people who were going through that process who really ought never to have been detained because they were quite vulnerable. For example, they may be torture survivors, or they may have been trafficked, or their cases were quite complicated, so it wouldn't be possible to decide their cases within the quite timetable that was this sort of distinct fast track. That's what it was called, the fast track. So all the kind of timescales for making a decision were fairly tight, as were the timescales for putting together an appeal. But the government was very clear that the process was working well, and it simply was not prepared to negotiate on anything. And we came across a case of a young person who was in her early 20s, who had been detained in Yarswood Detention Centre, and she had not been very well represented by her previous solicitor. And we took on her case, and the more work we did on her case, because she had been put through this detained fast-track process, the more we found out how the process actually works in practice as a whole, because everything that could go wrong in her case had gone wrong, because she'd been subjected to quite a serious attack in her country of origin, and had sustained scarring, but none of that was picked up. She was badly represented. She asked for more time to put together, or ask for a medical report to demonstrate that she had the scars that she said she had, and she just wasn't given it because of the tight timescales, and she was nearly removed from the UK until we got involved about 3 years ago now in her case. So as a result of the work of unpicking what had happened in her case, we realised that the whole of this process was actually very problematic. And so we worked with a charity called Detention Action, which had also been very concerned and had prepared a report called Fast Track to Despair in 2011 or 2012 about the detained fast track process, to see if it would be possible for Detention Action to bring a challenge in its own name, rather than using an individual client, because there were so many people within the detained fast track who were unrepresented, so there was nobody to speak for them in terms of lawyers. So we made an application to the court challenging the fairness of the whole process as it operates, including the appeals, and the fact that the detention for that length of time was a lot longer than the process that the Home Office had introduced in 2000, when they said it would be 7 to 10 days. Now people are being detained for up to 4 to 6 weeks, and often longer. So we had a hearing in court last year in December, and then we got a judgment in July this year, where the judge in the High Court said that the process was operating unlawfully, although in principle they could have a detain fast track. The way it was working, certainly as at the beginning of July, was unlawful, because none of the safeguards to make sure people who shouldn't be in the process were taken out. For example, torture survivors, people who'd been trafficked, people whose cases were too complicated. They simply weren't being taken out in the way that they ought to have. And although he felt that although there were so many deficiencies on its own, each of the deficiencies didn't make the process as a whole unlawful, but the combination of the deficiency and the final straw was that the lawyers who were trying to represent these people simply didn't have enough time to do their jobs, meant that the whole thing was just not working lawfully. There was one bit of the process which we were particularly concerned about, which was about detaining people for their appeal when they've done nothing wrong except appealed against the decision to refuse asylum, which was the bit that was added on in 2003. And the judge didn't really rule on that part for various reasons, and we felt that he should have. So we appealed to the Court of Appeal, and detention actions appeal was heard at the end of October, and in fact judgment is going to be given tomorrow on that. So we'll see what the Court of Appeal has to say about whether that part of the process is unlawful or not. And our main concern is that when the Home Office is making a decision on somebody's case for asylum, it's the decision maker. So it's not the opponent, it's actually the duty is to investigate and to work out what somebody's case is, and based on the account they give, decide whether or not the Home Office thinks the person's a refugee or not. If not, to give a right of appeal. But once that decision-making process is over, the Home Office's role changes, because it then becomes the other person's opponent in an appeal. Because the Home Office wants to win the appeal, and the appellant wants to win the appeal as well, so they're kind of adversaries. And we said that it can't be right that your opponent can lock you up in circumstances where by locking you up, it's going to make it very much more difficult for you to prepare your appeal, because your lawyer has to come and see you, you can't go and see your lawyer, your barrister has to come and see you, whereas if you're in the community, you can go and see your barrister in their office, and so on. And there are limited times when lawyers can go in to see their clients. So we said it's just not fair, because it puts you in a position where it's much more difficult for the lawyers to do their job, and puts the Home Office at a massive advantage, because it's more likely that the asylum seeker is going to be unsuccessful in their appeal, just because they haven't got the time or the facilities to do the job properly. So we said, how can it be right that your opponent has that much power over you and can detain you? So we'll have to see whether or not the Court of Appeal agrees with us. So that is going to be handed down tomorrow at 2 o'clock.
Oh, that's exciting.
Court of Appeal. So that's an example of a process which around 2,000 people a year go through at the moment. And so, although it's still operating, we're trying to the Home Office is talking to the solicitors working in the process and the other NGOs concerned about the safeguards, and we're monitoring to see how it's working on the ground, and whether the improvements that the Home Office has made have made the process lawful, and if not, whether we should go back to court or what. So we're still monitoring that first part of the process as well.
So your work with migrants and asylum seekers seems to be quite tedious and quite difficult, would you say?
I wouldn't say it's tedious, it's actually very interesting. Because but it is difficult and it's challenging. It's interesting because you're working on an issue, so you haven't got a client who comes in and says, this is my problem, and then you advise them whether you can do something about it or not, and if you can, you get on and do something about it, and hopefully you win, the client gets what they want, and they go off happy, hopefully. Whereas this is actually working on an issue, where you're kind of saying, how can we sort out this issue that affects a large number of people? So first of all, you've got to work out whether there's a problem, and then you've got to work out what the most appropriate solution might be, because court proceedings are quite unpredictable, and it's, you know, to take a case to court is an option of last resort, because it's always good if you can sit around a table and reach an agreement. Then everybody is likely to hold to that a lot more than going to court and the judge tells you you did this wrong and you did that wrong. But sometimes it's not possible to resolve it, in which case you kind of try and work out a way of going into court and then seeing what the judge does. So it is challenging, because you have to do lots of work in order to prepare the case and make sure you have the best possible case they can put forward, which takes a lot of time and a lot of work. It's like, I think that the analogy is the way people say, well, it's not like sprinting, it's more like running a marathon. So it's a long game. You know. And even when you do get a positive judgment, you then got to make sure that the Home Office is doing what it's supposed to, so that all that translates into real change on the ground.
Understand. Going back to your point